Hi, and welcome to our discussion about Household versus Moran, in case you know something about. Before we get started talking about the opinion, I want to just get a little bit of background from each of you, how you got involved in the case, what your practice was like at the time, where you were in the stage of your career. I don't know if you want to.
Sure. Well, I started at Skadden in September of 1970. So by 1984, I'd been a partner for, I guess, about 8 years. And my practice was almost entirely centered on takeover litigation. And I got involved in household because I was asked to by, I think, Joe Flom, when the CEO of Household, John Moran, came over and said that the company he's on the board of had adopted a poison pill and he'd like to challenge it. And Joe Flom asked me to handle the litigation.
I joined Skadden in May of 1968 as the 21st lawyer after 5 years in the U.S. Attorney's Office under Bob Morgenthau. By 1984, had been a partner for about 14 years, doing mostly securities work and takeover work, and also some white collar. I got involved in the household matter about 4 or 5 days before the case was going to be tried. I walked by a conference room and I saw Stu and Rod and about 7 other people in there. So, as I was wont to do, I walked in and sat and listened to them. And within an hour, Stu decided, okay, you're part of the team and you're going to handle Alan Greenberg, put him on as a witness, and you're also going to cross-examine their main witness, Jay Higgins. That's your role. And that's how I got involved.
So your client was John Moran. He had made some indications that he was interested in taking over Household, but it wasn't clear, at least from the opinion, that he had a very well-developed strategy to take over the company. What was motivating him? What was motivating the challenge of the pill? I mean,
He'd like to take over the company.
was it much more? Were his thought process much more advanced? I mean, it
Well,
seems from the face of the opinion that he's, he had a couple of back channel discussions. Maybe thought the stock was undervalued. You got a company that has 3 lines of business, none of which really matched up. You've got rental cars, financial services, and groceries. And he thought maybe separating them, busting them up, could deliver more value ultimately. But he still 5%, $2 billion company.
Dyson Kistner Moran was a leveraged buyout house, one of the earliest. And John invested in companies and looked at companies as the CEO of DKM with the view that he might like to own them and make a profit from doing that. So this was not an abstract exercise. I don't think.
Now, was it, and that's what I wanted to get, is not an abstract exercise. Was he looking at this in terms of, if Household can pull this off, this might be an impediment not only in this particular case, but moving forward?
Well, there were two motivating factors. One was Moran's. His business was LBOs, and poison pills could be an impediment to that. And the other was Joe Flom, who saw this creation by his friend and arch rival, Marty Lipton, and didn't want it to survive.
So if you got Household in 1984, thinks of itself as a potential takeover target. They hire Marty Lipton of Wachtell, Goldman Sachs. They give a huge presentation about the poison pill, which they ultimately adopt. But at that meeting, it was an August 14th meeting, they actually adopted a series of potential defensive measures, including the pill, but also they had the board adopt a statement to the effect that they believed the company should continue as an independent company. They amended their bylaws to regulate the calling of special meetings by stockholders. And they also amended their ESOP to allow the individual participants, rather than the trustee, to tender the shares in the underlying offer. And then, of course, they adopted the pill. At that meeting, interestingly, John Moran voted for all but the pill. But there's also a reference in the Chancery Court opinion to a pointed discussion. I think that's how the Chancery Court describes it. I imagine it was indeed very pointed between John Moran and Marty Lipton regarding essentially whether Delaware's corporate law was broad enough to capture constituencies other than just the stockholders, and whether the directors had to consider interests like the employees, the community, broader constituency bases. I think ultimately the Delaware courts have articulated the view that it is the stockholders to whom directors owe primarily their duties. But I wonder if that philosophical debate was at the heart of this case in any way, and whether that was a focus of your thinking at all.
I think the short answer is no. This was a crusade against the pill, and frankly, driven in major part by Joe Flom's desire to have the pill thrown out as an improper device. Marty Lipton has, over the years, and well ahead of his time, been an incredibly successful at doing what the Federalist Society and other advocacy groups have done, which is trying to sell his ideas of what the law ought to be. And so he's had articles in the Harvard Law Review that were written by people who had been summer associates at his firm. He's had a lot of press stuff. He's had an impact on the Delaware courts in selling his sort of philosophy. And I think the notion in the early to mid 80s of multiple constituencies, each having a right to be considered, is one which was adopted by some states in their anti-takeover laws, and one that Marty was pushing hard. But our focus was to knock out the pill, and that really could only be the sole focus, because none of us could figure out what the pill was, how it worked, how to attack it. We didn't have time to consider anything else.
So the key challenge, and it is interesting you say that, because most of the challenge was based on technical validity of the pill, primarily right. Whether the board had the ability to adopt it under the general corporation law, specifically section 157. You had a couple of arguments. One, was it just a sham security? Two, 157 talks about rights and options to purchase stock of the corporation. This pill was kind of a first generation pill that really had primarily the flip over as the poison, which meant essentially, once someone became an acquiring person, if there was an acquisition on the back end, then the rights holders would get to buy discount stock of the acquirer, causing dilution on that end. And so there was an argument that this was not a right under Section 157. It was a right to purchase someone else's stock. That can't be right. There was also the notion that isn't this just a restriction on transfer under Section 202, and one that was impermissibly adopted because the stockholders did not approve it, or the parties whose stock it was purporting to restrict did not approve it. That did seem to be the focus of the argument, and that's where you spent most of your time. I want to just see if you can kind of develop if you thought those were the strongest arguments, or if you thought there was some other.
That's maybe from reading the opinion, but we had 10 days of trial, and the 10 days of trial didn't involve those issues. The 10 days of trial listened to experts testifying the impact on the pill on the takeover process, the directors testifying to their informed basis in adopting the pill, to their loyalty to the company, to the fact that they wouldn't abuse their power. You had something like 14 or 15 very important people testifying. And so while you're right, one of the principal arguments was that the pill was essentially involved a sham security because it would never become exercisable, and therefore, Section 157 didn't authorize it. that I don't think was enough for Joe, because you could always figure out a way to find another statute.
Mm-hmm.
What Joe wanted was essentially a ruling that it was a matter of business judgment that you could not adopt a pill given the consequences of the pill becoming exercisable.
Mm-hmm.
And that's what the focus of 10 or 11 days of examination and cross-examination by 3 lawyers on our side, you, me, and Rod, and Mike Schwartz, Charlie Richards, and George Katz on the other. I mean, that was what made the case so interesting, plus the characters who testified. It was not some dry, argument. We could have moved for summary judgment if that was the real issue. But that's not what was wanted here. We wanted a declaration that the pill was invalid, and don't start putting them in all other corporations, because you could then amend statutes everywhere to take care of that statutory problem.
And we, I think, had a better than 50% chance of winning the case on the grounds of due care. The directors had no clue what the pill did. And in the depositions, we established that by simply asking them about the pill. And they just had no idea. So we could have gone in and won the case, potentially on that ground, but then they would have just gone back and informed the board better and adopted the pill again. So this was not about winning this case. It was about beating the pill. And so things that were short of an absolute bar on the pill really weren't viable options.
So it is interesting that you say that, because that doesn't necessarily emerge from the face of the opinion. And so I do want to develop this a little bit more, because in the opinion you hear, there's one director who says, the longest I've ever spent on a single topic. And, we had a meeting 2 hours long, and we got, all of these materials, including an article from Fortune magazine that were mailed out to us, a week or two before the meeting. And I imagine, though, that the pill at the time was, hey, look, a poison pill is a very complicated instrument to begin with.
Well, it was also unique.
And it was very...
So as lawyers, when we started looking at it, none of us had a clue what to make of it. So there are two things you do. You struggle to find a statutory basis for why it's invalid. You examine whether or not the directors were informed when they adopted it. But since, and I decided this very early, that doing that really is a Pyrrhic victory. Mm-hmm. So we had to find some statutory basis, something in the Delaware law that simply said this is wrong. I think we actually found something, which we haven't talked about yet, which is interference with proxy suffrage. Because if you read Justice Walsh's opinion, he in fact finds that the pill interferes with proxy suffrage, but then concludes by saying, but given the protecting the corporation, it's okay to take voting rights away from shareholders. That seems so inconsistent with Delaware law that I actually thought we had a shot, which shows my naivete. I think we had a shot of the Supreme Court saying you can't do that to the voting rights. But the other stuff, whether it violated 157, whether it was a sham, none of that had any sex appeal. Mm-hmm. And as Mike can tell you, the sort of business and social and political environment was not favorable to our position.
And that's what I do want to get into. How do you think that the political climate at the time affected, if at all, the thinking at the Chancery Court and Supreme Court level?
Well, at the time, you had two movements going on. You had one movement of emphasizing the rights of shareholders. You had the emergence of Mike Milken and already availability of enormous amounts of money. You had people like Boone Pickens, Irwin Jacobs, willing to make offers for companies and then accept green mail to be taken out of their positions. You had academics like Michael Jensen at Harvard, Mike Bradley, Easterbrook, all saying that takeovers are good for the economy. But then on the other side, you had the business establishment saying, wait a minute, there are a lot of abuses to takeovers. You have companies selling off assets when they shouldn't be. You have employees losing their job because how are you going to take care of the debt that was incurred in a takeover? You had the Greenmail situations. You had Pac-Man, which was an absurd situation between Martin Marietta and Bendix. So, and you had Marty Lipton on their side, and you had what Walsh very cleverly called a clash of fundamental structures within the corporation. The rights of the shareholders to accept tender offers and the rights of the directors to protect the long-term interests of shareholders. Very apt statement by him. Now, I think at the time of trial, we were losing that battle, and it's reflected in the opinions. And this really surprised me. You look at the opinions, they talk about bust-up takeovers, talk about coercive acquisition techniques. They were just relishing the judges in this language. And that surprised me. I didn't expect that was going to happen. There was no sympathy on their side or the judge's side for the person who wanted to be free to make takeovers.
And which maybe shouldn't be surprising in retrospect. The other major political force is the unions. And the unions were all against this because their people lost their jobs. So you've got the business community and the labor community lobbying politicians, by the way, people who make donations to politicians, lobbying the politicians to adopt laws and to block takeovers. And then if you look at the people who were making the takeover proposals, they were not exactly the most attractive people in the world. They were wild men, a lot of them, and grandiose, and talked in very colorful terms, and maybe lived very big, but they didn't seem to be people who were terribly concerned about the people whose businesses and jobs they would end up owning. So, you know, in the end, I guess Mike's been doing this longer than I have, but I've been trying cases for about 48 years, and I've never felt that anything but the facts mattered and how they hit the decider, whether it was a jury or a judge. Who was the good person? Who was the evil person? Who do I like and who do I not like? And that tends to determine how the cases come out. And here you had both business and labor and the politicians against the position that we were taking. And you have a bunch of financial manipulators, to put it nicely, who can borrow a lot of money, and they borrow by selling something called junk bonds, which doesn't sound very nice, to take over a company, sell off its parts, fire a lot of people. Not an attractive picture.
Now, that said, you did have one advocate in your corner from the outside, which is the SEC, who filed an amicus brief.
Nobody pays any attention to the
Yeah,
SEC.
yeah, it was poorly done on their part. They went pretty far. First they relied on, to a large extent, on Ace Greenberg's testimony, who was my witness. And Greenberg did not come across as a good witness before Walsh. I remember Wachtel would refer to him as having a vested ideological opposition to any defensive steps taken by the directors. And that's what he was. He was very skeptical about directors. And the SEC placed primary reliance on him, and then they said that the pill would not just deter two-tier offers, but virtually any takeover. I still remember that, virtually any takeover, because the Supreme Court, McNeely, stuffed that right back down their throats when they cited what Jimmy Goldsmith did with Crown Zellerback, which we can get to later on.
Yeah, and that's exactly where I wanted to go, because in between the time of the Chancery Court ruling and the Supreme Court, you do have the Southern District of New York basically denying Crown Zellerbach's motion to enjoin Sir James Goldsmith's proposal to acquire, through their pill threshold. I think he had 19.9 at the time and said he was going to go up. And that was relied upon by the Supreme Court as evidence of, I don't know how much credibility I have to give to the SEC's position, or that position generally, that this is going to prevent all tender offers, because here's one that happened.
Well, and also it knocked the underpinnings from our argument that the rights were a sham and would never be exercised.
Yeah.
Because in Crown Zellerbach, which had the exact same pill as Household, Sir James, after giving 48 hours notice to Crown Zellerbach, said, I'm going to buy over 20%, and you have until Monday at 5 o'clock.
Yeah.
And they didn't pull the pill. They went before Judge Cannella. I argued against it. And I was in an anomalous situation. I knew a week from now, Shapiro would be arguing in the Supreme Court that the pill was invalid because it would prevent takeovers. Well, and would never be exercised. Well, here I'm in court saying that Sir James Goldsmith should be allowed to go through the pill if that's what he wants to do. And Cannella referred to it as a high-stakes game of chicken. Beautiful phrase.
Yeah, he was a great judge.
Judge, yes. I knew him from the U.S. Attorney's Office. I knew he was very conservative, and he was not going to give an injunction in this situation. And for Sullivan and Cromwell to be as audacious as they were, irreparable injury, they're going to take over the company to make it acquisition-proof. When they had the power to prevent it, he was going to buy it. So Jimmy goes through the pill, and he owns more than 20% of the stock. And there's this wonderful quote. No one had anticipated someone like Sir James Goldsmith, because what he said was, when we got to 19%, I told them I was going to explode the pill and buy more shares. They didn't believe me. All along, they thought I was bluffing. And that's what he was, a risk taker. And
if you knew Jimmy Goldsmith, you would not think he was bluffing, but people didn't anticipate.
Right.
He was a gambler.
Stu knew. Yeah, he was. His father cut him off when he was in the 8th grade at some prep school in England. Cut him off from any money and support. So he went to the racetrack with some money and hit a 5-horse parlay. And that then secured his education for the next couple of years.
He was an amazing.
And so what he did hurt us, I thought, more than it should have. But McNeely just jumped on it for two of our principal arguments.
Well, it was a self-inflicted wound. If you argue that something is impossible. There are too many smart people out there. They're going to find a way around it. If you argue something is inequitable in these circumstances, you have a shot. But to prove impossibility is, to coin a phrase, impossible. Right? And we were being driven by our senior partner, who was in this head-to-head battle with his very close friend but rival over this device. And frankly, after the Unical decision came down, anybody who was not deeply enmeshed but could stand back could see that, the Supreme Court had said, all right, we'll reserve to ourselves, the courts, the ability to evaluate how directors use their powers. That doesn't mean we stop them from having powers. It just means that we get the chance to say whether they use them appropriately or not, which is a great place for judges to be in, right? Keeps them in the game. And it was a predictable outcome, except for that one issue, the proxy issue, where Justice Walsh had found that this really interfered with the proxy rights, and that was a bedrock issue. You can have multiple classes of directors. You can do all sorts of things as long as you let shareholders vote. And this device stopped shareholders from gathering together to vote. They couldn't put together a group of 25% or 20%, there was expert testimony that was absurd from Georgeson at the trial that it didn't matter how many shares you owned. That didn't affect whether you could win a proxy contest or not. And
You remember that chart that he presented?
yeah, it was just absurd. And Justice Walsh, to his credit, did not really adopt that. I cross-examined, and we had no discovery of Georgeson. For some reason,
Right.
I don't remember why, but for some reason there had been no discovery. So they came in and they testified and they had a chart, and I cross-examined them, not terribly effectively, but the testimony seemed so absurd, and Walsh didn't buy it. And he found in his opinion that this does interfere with proxy rights. It's inescapable, and then the Supreme Court opinion simply
Dismissed it.
rejected his
Right.
fact findings without any explanation and dismissed it because if you actually dealt with the issue, there was no way you could do what they wanted to do, which was affirm. But again, you had, on that panel, you didn't have a lot of corporate expertise at the Supreme Court. And you had a huge amount of political
Headwinds.
going on.
That's a good question. So at that time, did you have corporate clients at Skadden for whom you were acting in a defensive capacity? And did
Of
you
course.
feel that a frontal attack of the poison pill may cause, some of your clients to feel alienated or
Joe Flom was the silver bullet. People paid, when I started the firm, people were paying $25,000 annual retainers simply to have him available in case at any time in the future anyone attacked them. By the time that practice ended, I think it was 10 times that or more. That's how that firm grew. Because then Joe would say to them, look, you've given us all this money as a retainer. You really ought to be using our tax services or our EPA services. No reason to waste the money But so people weren't going to get alienated from Joe Flom because he was regarded as the best protector you could have. And if he took a position that wasn't absolutely, wasn't a Marty Lipton kind of position, which was completely devoted to defense, they weren't going to walk away from Flom. I don't think that was a risk really at all.
I think there was a little bit of skittishness, though, Stu. But at the same time, we didn't put any pills in for anybody. But not many pills were put in because no one knew what was going to happen in the Supreme Court. And of course, the day after the Supreme Court, Skadden came out with this flip-in pill. It was no longer going to be flip-over that Goldsmith was able to take advantage of because he delayed the merger till later on. The bad consequences would take place immediately once you went over 19.9%. I remember Peter Atkins, the chair of our litigation, our corporate department, had that ready to go, and they were traveling around the country, all the corporate guys, sticking that pill in.
Yeah, we represented both sides as opposed to Wachtell, so we always had that issue. And occasionally, like in the Data Point case, we'd actually bring in another law firm to argue the case because we had already put the same bylaws in other corporations. But our clients understood that they wanted us on retainer, that was part of the price. We had to be free to represent other clients. And, there was a conflict waiver kind of provision in all the retainers that dealt with those kind of things.
I'm going to ask you to speculate a little bit because I do like the idea of, Crown-Zellerbach household, kind of generation one poison pill without the flip-in, which did allow Sir James Goldsmith to go over and just hang out for a little while and see what happens without any immediate dilution to his stake. So I just want to ask you to speculate, if Household's pill had included a flip-in provision, you think you would have had better odds and maybe even won the case?
No.
Same outcome.
No. If they were willing to simply ignore the proxy impact, which was the strongest non-statutory attack, this was, look, as a practical matter, all this pill did was give the board power which they could waive. which meant that their decisions were reviewable. So if it had been an atomic bomb, it didn't matter what it was. It simply put them in a position where they had a reviewable power. And if you go back to Schnell against Chris-Craft, that's a concept that, at least from that case, has been present in Delaware law. You have a power, but if you use it inequitably, it'll be enjoined. And this was just such a new and strange and puzzling device that I don't think any of us, I certainly didn't, have the power to sort of step back and say to Flom, look, this is saying that they can't do this because it could be bad, and so it ought to be forever enjoined is simply not a winning argument.
I agree with Stu. I mean, when you go to the end of Walsh's opinion, he talks about that the plan creates the potential for the misuse of directorial authority. And then he says, through its power to redeem the rights before a triggering event occurs, the household board has assumed a plenary negotiating role. It has also taken upon himself the responsibility for assuring the rights are not triggered in such a fashion as to inflict harm upon the corporation by rendering it acquisition-proof. It cannot be assumed that the board will act contrary to the interests of the shareholders. Those events and plaintiff's fears must await another day. On the evidence presented, the adoption of the rights plan is an appropriate exercise of managerial judgment under the business judgment rule. And no matter what, as Stu says, had been presented to him, he would have found the same thing as he found right there. I'm not going to rule ahead of time they're going to misuse their authority. We'll wait and see what happens.
And so that is, so setting aside all the technical arguments, and obviously we've got all the twice tested, first in law, then in equity, but setting aside the technical arguments, did you think, you look at Household's board, 16 people, 9 of them I think were outside directors. Did you think, how are we going to go at attacking what they did on equitable grounds what's their interest here?
That's a very good point. And the problem we had was that their board was very good. You had John Whitehead, head of Goldman Sachs, coming up through the ranks, incredible World War II record.
Son of a lineman for the power company.
Right. Later Assistant Secretary of the Treasury. You had Ray Trube, a friend of both of ours, was on at least a dozen boards. Had seen
Supreme
everything.
Court law clerk.
Right. You had Ray Tower, who had been on the marathon board during the whole mobile marathon situation, and emphasized how chaotic that situation was and how you had to quickly do an asset lockup on one of their biggest subsidiaries, and how instead the pill gave you this flexibility to sit back and deal with a bidder and try and work out the best possible thing for shareholders. Now, maybe they didn't know all the ramifications of the pill. I give you that. But Lipton set it up so that they were certainly informed, number one. And number two, it was very hard to argue that these people were being disloyal. Even Moran testified that he thought Whitehead was an honest guy.
Yeah. Now, Whitehead,
and there was no offer. There was no
offer, right?
I mean, so
I think you had Murkison coming in and saying, "Hey, we'd like to chat with you at some point."
Yeah, but there was no, if there had been a live offer on the table, then the dynamic would have changed. But here, this is completely abstract. It's just this device shouldn't be permitted because the legislature, called for a vote on mergers, but it didn't call for a vote on tender offers, and you're effectively taking away from shareholders, the unilateral ability to accept an offer for their shares. And so you search for statutory bases, but there's nothing very sexy about any of that. If there had been an offer on the table, and of course Moran was testifying that he was not going to pursue an offer, but
different situation. You're right.
It would have been different. And just as if Perlman hadn't bid 58, to top the Forsman bid, you might have had a different, you had a risk of a different outcome, because you don't generally get injunctions favoring what might be lower bids. You know, so in the end, the market dynamics are really important to these judicial decisions.
On this very issue, when Stu and I were at Penn Law School and Leo was there, he was a little bit critical about why did we bring this suit not in the context of a takeover, that we should have maybe waited to the takeover. I think the response is clear. You have a client coming into you and saying that this, I don't think this is proper. This is right, what they're doing. And you also, instead of having some 50-share stockholder, you have an actual director. So those taken together made the bringing of the lawsuit at that point, I think, a reasonable one. Notwithstanding, others have criticized us for bringing it at the time, and also not bringing it in New York, where there was some law at the time that might have been more helpful to us. But that wouldn't have been, that would not have served Joe's purpose. Joe's purpose was Delaware law. It's illegal under Delaware law. I don't care about New York law.
Although Joe never really came up with a rationale that we could sell. He had a strong commitment to his belief, but you know.
You never met Joe. He was brilliant, and also a very good person, and driven, and you would go to the end for the guy.
Yeah. That is great. One thing I did want to ask about, though, now as we talk about the board, you did have Mr. Whitehead, who was the director at Goldman, and Goldman was working, I think, with Wachtell and advising the board on defensive measures, and I think Mr. Whitehead was one of, you know, in addition to Mr. Moran, who voted against the adoption of the pill, saying he didn't want, I don't think he was philosophically opposed to it, but he said he didn't want the company to be a guinea pig.
Yeah.
How much fun did you have with that, given that his partners were evidently advising that this was a structure you could use, and he was throwing up the caution flag?
Well, I'll give you another piece of it you may not know. His partner, Bob Rubin, was in Washington lobbying against the pill as head of the arbitrage department of Goldman Sachs. As I was down there with him. My father actually talked to me before I cross-examined John Whitehead, and he said, "You are be very respectful, very polite, and he's a very important fellow. The court will not like it if you try to touch him up." And I don't, was it that time, was John's daughter working for us? I think she was.
Ann
his
was.
daughter was also an associate at Skadden.
So
there were a lot of
touches.
No, but you followed your father's advice,
and so
rightfully so, because he was such an impressive person.
Yeah, there was nothing you could do with John,
Right.
except, you know, yes, he voted against it. But he thought, you know, it was not right. He didn't want the company, which was, you know, in a quiet mode, to all of a sudden become part of some big brouhaha. Ray Trobe, who Mike mentioned earlier, who had an enormously distinguished resume, you know, partner at Lazard and Supreme Court law clerk and all sorts of stuff, and on many boards, including one of our clients at the time, you know, agreed that anything that interfered with proxy right would be a terrible thing. But none of that. In the end, it was very clear that the political climate did not favor raiders and bust-up artists, and all these terms that were created either by investment bankers or the press that were all negative in terms of the people making these offers.
Yeah, I have some bust-up artists, front-end loaded tender offers, bootstrap takeovers, coercive acquisition techniques.
And what's remarkable about it, if you
They loved
actually analyze the transactions, the transactions that are most coercive are the ones that actually involve you know, buying a portion of the company but not buying all of it, but this pill encouraged that. But
As in the case of Crown Deli.
yeah, but it was just. I think we were naive not to recognize that there was really no constituency for these raiders being financed by junk bonds who were going to sell off things and cause people to lose their jobs. There just wasn't. And judges are susceptible to those atmospherics.
To show how political the situation was, I referenced that Alan Greenberg, Ace Greenberg from Bear Stearns, testified for us as an expert. And he, of course, came from the trading side. He was a great, great trader, and he was our Wall Street witness. Why was he our Wall Street witness? Because we couldn't get anybody else to testify. I was in the room once with Joe when someone whose name I will not mention, and Joe was trying to get to testify, someone with white hair. I hate to say that, with white hair. And he said, Joe, I can't do it. I promise Marty that even though I'm not going to testify for their side, I'm not going to testify for you.
But he was also a guy who bought or owned less than a majority or less than all of the shares of most of the companies that he owned. So if he had testified for the other side, he would have not been helpful to them either. It was interesting. I mean, the practical reality of the way the markets work and the way people own companies and the abstract sort of legal arguments that were being made just didn't meet at all. The arguments made on the other side were equally discordant with reality. They just didn't. They weren't right. If you lived in the market, as many of the people we dealt with did, the lawyers were arguing nonsense about a lot of this.
Wachtel was arguing, well, you could always make an offer with a 95% minimum. So when I was cross-examining Jay Higgins from Solomon Brothers, head of the M&A department, he said, that's ridiculous. No one ever does something like that.
Yeah.
They said you could do a consent solicitation. He said, never been done before, not going to happen.
Yeah.
Two-tier offers, he admitted, as long as the blended price is fair, that's fine. But he said, but you can't do a two-tier offer here. And as far as bust-up takeovers, I have to read this quote to you, because this was typified. Mr. Higgins, so long as they pay a fair price, who cares if the company wants to sell off assets? People buy stocks to make money. I mean it. It is America.
Yeah.
All right, that was just perfect.
That is a great quote.
Yes, it is. And then when I finally pressed him, how could you make any offer without the consent of the board, he finally says, quote, the acquirer can burn up the rights in a gymnasium. Then he admits that's an absurd example, as most of mine are. And so I stupidly think to myself, my God, I think I've scored a point here.
But
maybe we're going to win, but who cared? It didn't.
Well, but the problem you
matter.
have is, and I've said this to Bill Allen, I've said it to Leo Strine, have you ever sat in a board meeting and discussed, a corporate transaction? Have you ever drafted a merger agreement? Have you ever actually lived in this world that you're making rulings about? Remember a client who's one of the most successful investment managers in the latter part of the 20th century, who took his mutual fund complex from $2 million to $32 billion before he sold the management company.
Oh, I know you're talking
And he went down and spoke in Delaware to a luncheon that I think Bill Allen, when he was chancellor, had arranged, and explained to them that a ruling they'd made in a particular case had cost the shareholders $1 billion in market value. And they were stunned. They had no idea. And, so we've got judges who, and in Delaware, with all due respect, or maybe not so much, to the Delaware Supreme Court and the Chancery Court, who look for pigeonholes, for legal pigeonholes to put fact patterns in. And it is truly an abstract exercise, and none of them, or now that's not true because Andy Bouchard certainly has been involved in a lot of this, but a lot of them have never actually been involved in a real life situation and understand the mechanics of how things happen, the economics of them. So, we argue household, and who was on the panel?
McNeely, Moore, and I don't remember the third one.
The third one was,
It was
another
a
Superior Court judge.
Yeah.
So you have two justices who have had no corporate law experience at all. And you're trying to argue something that for people who live in that world was so complex they had difficulty comprehending it, figuring it out. You're trying to argue to them so they can decide whether something is appropriate or not.
Mm-hmm.
That doesn't make any sense, right? I mean, to persuade people, either they have to trust you,
Chief Justice Christie.
Christie. Yeah. They either have to trust you, or you have to find some device that helps them understand something that they have no comprehension of going into. And that's the problem you face as a litigator in these cases.
And the problem your father faced in the Supreme Court, because it was clear that McNeely, who wrote the opinion, had no clue what this case was all about.
Yeah.
I mean, you
But
read
both
that
of
opinion,
us have tried cases and argued cases all over the country, in Georgia and California and Dakota, whatever, and you're in front of judges who you either convince that you know so much that they can rely on, and that you're honest, that they can rely on what you're saying, or they have no clue as to what they're dealing with. It's like me being a judge on a patent case, right? And that's, and I once had a conversation with, I think, Charlie Richards, and said, when you're retiring, why don't you go on the Chancery Court? You've been in these cases for your whole career. Why don't some of you guys that are experienced agree to be judges for 6 years or something, so the court has really experienced judges? And he sort of brushed me and said, that's not practical or not possible. But if you're going to put people on these courts and they're going to deal with complex and significant economic transactions, and they have no background in it, that's asking an awful lot of them.
I hate to say I disagree with you in one respect, Stu. I thought Walsh certainly had it right in Revlon, clearly had it right in Revlon. He saw it through exactly
But that was
what had happened.
That was a human situation involving motivations of people as opposed to an economic situation. I had an argument in front of the Supreme Court in a case it was actually Leo Strine's first trial as a vice chancellor, and it was the other side was making an argument about a first refusal right based on some definition in the definition section of the contract, and that somehow overrode the first refusal right provision of the contract. And I had a 3-judge panel, and it split, so we ended up going en banc, and the Chief Justice Veazey was on the en banc panel, and this issue came up, and I said, well, as the Chief Justice knows, the definition sections of these contracts are often written by a first-year associate who's using a form down the hall and has nothing to do with the transaction. The substantive provisions are actually negotiated. And he looked at me and said, Mr. Shapiro, are you testifying now? I said, no, just calling upon your Honor's experience. And, but if he hadn't been on that panel and as a corporate lawyer experienced, I could have been, whistling in the wind. But I could see he understood that the substantive provision obviously overrides some form definition. But, some of the other justices, it wasn't so clear that they understood that because they'd never negotiated a contract.
Right.
And that's a problem.
So I think what I'd like to get each of you to do is to give your observations on two things: whether you think the court, both at the Chancery and Supreme Court level, got it right from a legal and policy standpoint, and you can use the benefit of hindsight and what you've seen, but I want to get your thoughts as to whether you think they got the law wrong and the policy right, or the policy wrong and the law wrong, or I want you to comment on those aspects.
I think that the decision was correct in terms of validating the pill as a device that they could create to give themselves the power to deal with a hostile takeover. I don't even pretend to be a lawyer. So whether 157 or some other provision of the Delaware statute was impaired or not, or invalid, or should invalidate, I don't know. On the proxy issue, I think they were wrong, and I think the fact findings that the Vice Chancellor or the Chancellor made were right, and that the Supreme Court didn't deal with them appropriately. So whether, and I think that the proxy, if the proxy right is to be that fundamental in Delaware law, then probably the pill should have been invalidated on that basis, but I suspect you can design around that by simply saying you can form whatever group you want to solicit proxies,
Solely for the purpose of proxy
but solely
contest.
for that purpose. So I think on a policy basis, the notion that the directors have some additional power to negotiate is a perfectly sensible one, and it certainly was beneficial to the bar.
Mm-hmm.
It's made for a lot more litigation and a lot more, interesting sort of lawsuits and appeals. The reasoning in the opinion, I think, is specious,
Yeah.
but I think the outcome is probably correct.
I essentially agree with Stu. There was no reason in the abstract to take away this power that the pill gave the board to negotiate with a potential acquirer. There were abuses that were going on. There were these people who were taking green mail. There were these asset sales at low prices. There was this ridiculous Pac-Man situation. And by saying we'll await a specific case, I think Walsh was right, because recall afterwards that in Interco, the pill was invalidated in that situation. Recall in Macmillan, they withdrew the pill because they had to. They knew it wasn't going to pass muster. So what Walsh said, we'll stand guard, we'll watch you, we'll examine your actions carefully. I think that was all right.
Mm-hmm.
As far as the rationale goes in dismissing our arguments, they were just trying to sustain Walsh in as unsophisticated way as I've ever seen. I think Moore, who had just written Unical, just didn't want to write another opinion right away, and that's why he gave it to McNeely.
Well, actually, McNeely was senior to him, I think.
I believe that.
Yeah, so McNeely may have assigned it to himself.
Whatever it was, if he assigned it to himself, knowing how little he knew, it surprised me, but I never knew McNeely. But you've read the opinion, and I think it's wanting in material respects.
Well, I have greatly enjoyed this discussion on household and appreciate all your observations.
I'll actually leave you with something that I read in one of the things, and it was a quote from Colin Seitz, who had been the chancellor in Delaware and then the chief judge of the Third Circuit, and sort of a legendary corporate law judge, and he said something like, corporate democracy is not the same as political democracy. Corporations are different entities than political entities, and so the rules have to meet the purposes of the entity and the nature of the entity. And we were making arguments that this is a violation of democracy. The shareholders own the corporation. They should be. And when I read that from Seitz, it sort of resonated with me that it was a great argument, but it really isn't. This isn't Athenian democracy where all the citizens get to vote. This is a business that has a lot of purposes, and shareholders are really not citizens. They are people who've invested some money. Mm-hmm. And they have a different, really different role.
Good perspective.
Yeah,
Very
well,
good
Seitz
perspective.
was a very thoughtful guy, a very, very interesting guy.
Your questions were quite incisive. They were helpful. And thank you for the opportunity.
It wasn't as
of hearing
painful as it
before.
usually is.
That is great to hear. I tried to-
loss.
It was
I have some
very good,
others
John.
that.
Very good, John.
That's great. I enjoyed it. I enjoyed
Good.
it a
It
lot.
was nice meeting you.
Nice
Yeah.
meeting you as well.
Yeah.
Thank you very much.